Ladies and gentlemen, good morning and welcome to this series on the Companies Act 2013. I've been doing a whole load of articles on this act for the last 2 years under a banner called the Smart CA Initiative, which is when a few of my friends suggested that I actually convert this into short video snippets, and here we go. This entire series is going to be titled as The Act and Its Impact, and I'm going to try and share as much as I can with you as very short 3-minute video presentations on the Act itself. So welcome to the Act and Its Impact Edition 1. And this is largely going to be on the overview and the construct of this Act. With the exception of the Hammurabi's Code of Law, the Arthashastra by Kautilya and the Manusmriti, very few legislations in world history have been proactive, and this Companies Act 2013 is no exception. It's a very regressive, punitive, decisive legislation that seeks to control India Inc. for a string and stream of successive misgovernance and failures that happened. While the US was very quick to respond with the Sarbanes-Oxley, we took a little bit of time in India, and now finally we have the Companies Act 2013. Now what is it that makes this act different? So first of all, in terms of the act itself, there are 29 chapters in this act, 470 sections and 7 schedules, as compared to the earlier act which had 13 parts, 658 sections and 15 schedules. Now what is it that's different about this act? Number one, it's an act that's been notified in parts. Now this act actually was passed sometime in August 2013 in the Rajya Sabha, and 98 sections of this act were notified for implementation in September 2013, and as of April 1, 2014, this stood at 283 totally notified for implementation. So it's notified in parts, which means for the remaining provisions of this act, one has to look at the 1956 law itself. The second interesting thing about this act is that there were very little transitionary provisions. You had transitionary provisions that gave us some time for audit rotation, some time for implementing a uniform financial year, but in a lot of other cases, the transitionary provisions were missing. How do you deal with loans to directors? How do you deal with loans from members? How do you deal with loans from directors' relatives at the commencement of this act, where the changes in the provisions were substantially different from the 1956 Act? So there was a lot of issues on transitional provisions, and clarity is still emerging. The third interesting thing about this act is that it's a rule-driven legislation. In about 300 plus places in this act, it says rules as may be prescribed. So who has to appoint an KMP? Certain companies as may be prescribed. Who has to appoint an independent director? Certain companies as may be prescribed. Who has to appoint a woman director? Certain companies as may be prescribed. Who needs to have an internal auditor? In the rules as may be prescribed. What companies does audit rotation apply? Rules as may be prescribed. So it's a very rule-driven legislation that can be deepened very easily. The next interesting thing about this act is that it carries extremely large penalties. Everything that was 500 odd is now maybe 5,000 or 50,000. That's part one. Two, for the first time you have slabbed penalties, which is a violation could carry a penalty anywhere from 50,000 to 5 lakhs, 5 lakhs to 25 lakhs, 1 lakh to 5 lakhs. And somebody is going to sit in judgment on how much is the penalty going to be. And another funny feature of these penalties is that sometimes they may bear no relation to the offence. I could have a loan to director, 185 violation of 50,000, but my penalties start much higher. So this act is act with teeth and very large penalties. The next interesting thing about this act is that it's, for the first time you see an act which is threshold driven compliances. The previous act Act was fairly simple. A certain provision would apply or not apply depending on whether a company was public, private or listed. But now, the applicability of a provision in certain cases, in a lot of cases, depends on the type of company, how much of share capital, turnover, net worth it has, and a financial attribute for such a parameter. We will discuss this part of threshold-based compliances in addition to as a separate feature. But what's important is today, for example, if you have a public company with more than 10 crores paid up capital, you need to appoint a KMP. Any company with more than 5 crores paid up capital, you need to have a company secretary. So these are illustrations of thresholds that we will elaborate further in addition to. And the next most important thing about this act is that it's a completely new regime for private limited companies. Today, doesn't matter who you are, whether you're public or private, the governance yardstick is more or less the same for most important sections of this act. Now, there has been a certain relaxation in the June 5th notification, 2015 notification. But again, when we deal with private limited companies as a separate chapter, you will understand that these relaxations are very, very minimal and most companies may not be benefited by these relaxations. And the last thing which is good about this act is that it aims at a one-place enshrinement. For example, you had componentization for the purpose of depreciation of assets, which was largely in IFRS. That's been brought in here. It's only the code of conduct that said an auditor cannot perform non-audit services exceeding a certain value for a client for certain categories of clients. Now that has been brought into the Companies Act in a section that refers to restricted services for statutory auditors, which is under section 144. So penalties for insider trading has come into this act. Independent directors, which is a clause 49 requirement, is now prescribed for certain large companies as well, which are not in the listed space. So, to summarize edition 1 of the act and its impact, it's notified in parts, it carries large penalties, it's rule driven, it's tentative, it recommends threshold based compliances, it's a one-place enshrinement of a lot of other things contained in various laws and regulations. And the last of all, what's likely to impact us most is that it's a completely new regime for private limited companies. Stay on for edition 2. Thank you very much.